Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have an incredibly important webinar. Oh, do we have to put a
You
disclaimer
can
of the
say
word
it.
shit?
No, you can say
All
it.
right,
It's okay. It was
we
an
could
adult
say
crowd.
it. Shit. I forgot to send my notice to owner. What now? How do I get paid? So without further ado, I introduce the amazing Alex Barthet.
Thanks, Ariella. My name is Alex Barthet. I am a board certified construction lawyer here in the great state of Florida. And today we're going to talk about what to do if you forget to send your notice to owner. And trust me, all is not lost. There are ways to still get paid. So let's get right into it. What are we going to talk about in detail today? So first, we're going to talk about the basic notice to owner and lien or bond claim rules. We need to make sure that everyone understands what the rules are. The best way to avoid missing a deadline is to know what the deadline is to begin with. Next, we'll talk about some of the most common exceptions that we see, and it may be good news for you. Maybe you didn't actually miss the deadline. Next, we'll talk about other bonds to go after. Sometimes there are bonds on projects that you may not know about that you could make a claim against and get paid. We'll talk about how to sue for breach of contract, how to sue for unjust enrichment. Those would be the other legal theories beyond the lien and bond claim that you can make a run at. And then, as we always do, we will answer any questions that you have. When you ask questions, you can use the GoToWebinar chat box, which should be on your screen. You can submit a question. We will answer all the questions at the end. Please make sure not to include any names of people or companies in your questions. So let's get right into it. So let's go over the basics. The basic notice to owner, lien, and bond claim rules. So you need to serve a notice to owner no later than 45 days from your first work on the project or delivery of materials to the site. Now let's break this sentence down. It's got a lot of parts to it. So the 45 days counts from the day after you deliver the material. So if I deliver materials today, tomorrow is day one. It counts every day, weekends and legal holidays through and including the 45th day. The only time you have a little bit extra is if the 45th day lands on a weekend or legal holiday when there would be no mail. So you can't expect the notice to owner to be received on the 45th day if that was, for example, a Sunday and there's no certified mail. So you may get a day or two extra in your notice to owner deadline. However, you should not be counting on that extra few days because of weekends. There is a rule that says that if you send your notice to owner by the 40th day, 40th day, even if it is never delivered, as long as you follow certain rules, it will be deemed properly served and delivered. So if you use SunRay, which you all should be using, SunRay Construction Solutions for your notice, what they will do is, as long as you get it to them with enough time, every day they go to the post office and they have a mail log, a manifest, and they get the post office to verify that each of the parcels that are being delivered by certified mail that day are in fact being accepted by the post office. So long as that is done by the 40th day and you have that manifest, then whether or not it is actually delivered, the mail truck could explode, catch on fire, and those packages and notices never get delivered, it is still deemed properly delivered under the service rule in the lien law. So what's the takeaway? You need to do your notice early. So that leads to the next question. How early can I send my notice? Our advice is you should send your notice roughly speaking at about the time you sign your contract. So if I sign a contract today and I may not start work for another 2 months, I can send my notice today or tomorrow or the week after. The 45 days from your first work is the absolute latest date to serve your notice to owner. So I can serve it earlier, but I can serve it no earlier than when I have a contract. So if someone says to me, hey, you're going to get that job, I can't send my notice today. I have to wait until I actually have a contract. Then I can serve my notice, even if I may not show up on the job for another week or 2 or month. So that's the first rule. The second rule is that you need to serve your notice of non-payment on the bonding company or record your claim of lien within 90 days of your last work or delivery of materials onto the job site. So 90 days is calendared or calculated based on the day after your last day of work. So if I work, today's my last day, then tomorrow is day 1. I count every day, weekend and legal holiday through and including the 90th day. And if the 90th day lands on a weekend or a legal holiday, then I would roll it over to the next day. So if the 90th day was a Saturday, it would go to Sunday. And if then Monday was a holiday, it would roll to Tuesday. So you could get potentially up to 93 days. But again, we don't want to wait that long to serve our notice of non-payment or record the claim of lien because it takes time to do it. So our advice typically is to do it within 60 days. At about day 60 from your last day of delivery of materials or last work on the project, that's when you really should start thinking about the claim of lien, notice of non-payment process, so that you're not rushing at the last minute. So the next question we often get is, what is last work on a project? It does not include punch list work. It does not include repair or warranty work. So if I'm an electrician and I finished my work, I passed my inspections, and then I'm called out to replace, 6 broken faceplates on light switches, that's not going to count to extend my lien or notice of non-payment deadline. So if I'm a painter and I have to go back and do some touch-up paint, that would probably be considered punch list or warranty work. That won't count. Change orders that are approved will count. So if I do work my 90 days, let's say I'm on day 70, they call me out, they sign a change order, and I have to install 3 new doors. I have now reset my 90 days, not when I sign the change order, but when I actually do that work. So those are some ways to renew your 90-day window. And then the last major rule is you have to file a lawsuit on your lien within 1 year of the recording date of the claim of lien. And on a bond claim, you have to file suit within 1 year from your last work on the project. Those two dates are not always the same, right? So on my lien foreclosure lawsuit, I have a little more time than on my bond claim lawsuit against the surety. So just be careful. And my advice is you should not be waiting anywhere near the 1 year deadline. You should be thinking about filing your lawsuit if you haven't been paid. Our typical advice is within 60 days of serving the notice of non-payment or recording the claim of lien. If you haven't been paid within 60 days of that date, and you don't have a good business reason to wait, maybe this is one job of 5 and you have a good relationship with the owner or contractor and you just want to keep waiting, that's fine. But generally speaking, there are not, your claim is not going to get better just because you wait. Project managers move, documents get lost, people's memories fade. So the longer you wait to enforce your lien or bond rights, usually the harder it is to get paid. So we usually say within about 60 days after you record your lien or serve your notice of non-payment, if you haven't been paid, that's when you need to start the process to enforce your lien and bond rights with a lawsuit. These are just the very basic rules. There's lots of exceptions, some of which we're going to go over now, but just keep these rules in mind as you move forward. So let's talk about what may be certain exceptions that apply because maybe you think you needed to serve a notice and you actually didn't. So let's talk about some of the most common exceptions. So one is that you don't need to serve a notice to owner when you have a direct contract with the owner. So if I am the plumber and the party that hired me is the owner of the property, then I don't need to serve a notice to owner. I should. Our advice is generally that you should have a process in your office that every project over a certain amount of money, you automatically notice. So you don't have to figure out, well, do I notice this job? Well, I don't have to notice this other job. You just have a process. Automatically, any job over a certain dollar threshold gets noticed. But if you have a direct contract with the owner, then you don't need to serve a notice to owner. Where this gets a little tricky is there are certain folks that are the owner and the contractor. So if the owner of the property is an entity and many of the same owners of that entity are also connected with the contractor, then if that contractor hires you, let's say again, I'm the plumber, I don't need to serve a notice to owner because the owner and the owner of the property and the owner of the construction company are affiliated entities. And therefore, that's another exception when a notice to owner is not needed because the law deems that situation to be one in which the owner and the contractor are effectively one. So the law deems the fact that you have a contract with the contractor as the same as having a contract with the owner. Now, I'm telling you these exceptions not so that you plan for them so you don't send a notice. I'm telling you, you should send your notice, but just know that there are certain exceptions that apply so that if things don't go well, maybe one of these exceptions will save you. Next, you don't need a notice to owner, and in this case, it's technically called a notice to contractor when you have a direct contract with the bonded contractor. So let's take an example. I'm the electrician. I am doing work for a general contractor, and that general contractor has a bond on this project. It may be a public job, it may be a private job, but the general contractor posted a bond on the project. I normally, if that bond didn't exist, in order to have lien rights, I would have needed to have served a notice to owner on the owner because I'm a subcontractor. But because the job is bonded by the general contractor, so there's a payment bond in place. How do I know there's a payment bond in place? I can look at the notice of commencement in the public record and it should reference the fact that the job is bonded. Maybe it says the bond is issued by Liberty Mutual, the Hartford, CNA. But because the job is bonded, I don't need to serve a notice to owner or a notice to contractor. And the reason is simple. My claim on a bonded job is against the contractor's surety. Well, the contractor knows I exist on this project because I signed a contract with him. I'm the electrician. I signed the contractor's subcontract. So I don't need to give this contractor an additional notice that I'm on the job because he already knows that I'm on the job. So the second major exception is that there's no notice to owner, notice to contractor needed when you have a direct contract with the bonded contractor on a bonded project, whether it's public or private. Another exception is that you don't need to serve a notice of non-payment when you have a direct contract with the bonded contractor on a public project. So let's run through an example. Let's say I am the roofer on a public job. Now this public job, let's say it's a school board project. The school board is the public entity. They hire a general contractor, and that general contractor has to post a bond because there are no lien rights available on a public job. So the law requires that any contract between a public owner and a general contractor over a certain amount, typically it's $400,000, has to be bonded. So we already know that if I'm the sub to the bonded contractor, I don't need to serve a notice to owner. That was the last rule we talked about. So I don't need to serve that notice within 45 days. I should, but I don't need to. Next, because the job is a public project, I don't even need to serve the notice of non-payment. That's the second notice within 90 days of my last work. I don't have to serve that second notice. So on a public project, if I have a contract, a direct contract with the bonded general contractor, then I don't need to serve a notice to owner, the 45-day notice, and I don't have to serve a notice of non-payment, the 90-day notice. All I have to do is file a lawsuit within 1 year of my last date of work on the job. That's the only obligation that I have to preserve my lien rights, or in this case, bond rights. Next, on a bonded project, the 45 days where I have to serve this notice to owner, technically called the notice to contractor, does not even begin to run until I have actual or constructive knowledge of that general contractor's bond. Let me give you another example. Let's say you are the subcontractor on a project. And the general contractor on this job posted a bond. But for reasons unknown, this general contractor made no reference to the bond in the notice of commencement. They didn't record a copy of the bond in the public record. So you have no way to know that this job is bonded. Let's say you miss the notice to owner deadline. You forgot to send it. What's interesting is that this 45 days doesn't even begin to start to run until you have actual or constructive knowledge of this bond, which is the mechanism that you have to make a claim on. So this actually happened to a client of ours. He was a mason on a school board project down in Homestead, and he totally forgot to send his notice to owner, notice to contractor, because he had a transition of certain personnel in his office and they screwed it up. So he comes to me and the job is completely done at this point. He's off the job. It's been about 2 months since he's off the job. And he says, Alex, I really screwed up. I forgot to send my notice to owner. So we did a little research and we found out that the contractor in this case did not record a copy of the bond, which is required. We did find a copy of the bond. And once we found it, we served our notice to owner. Now, remember, this is more than a year after the job started. This is about 60 days after he finished his work on the job. But because the time didn't start to run until we actually knew, once we knew, we sent that first notice. The next day, we served the notice of non-payment on the bond. And the day after that, we filed our lawsuit on the bond to get paid. He was owed roughly $100,000. And it took about 4 months of litigation, but we were able to convince the other side and the judge that their failure to comply with these rules meant that we still had a valid claim. And they ultimately paid us all of his money plus legal fees, costs, and interest. So that's an example of when you think that maybe because you didn't send a notice that you have no lien rights or bond rights, maybe you do because there's an exception that applies. So we went over several of these exceptions. There are still more, but these are the most common ones that apply. So what else can you do? The other thing to consider is look for a bond that may exist on the job that is that's different from the general contractor's bond. So let's say you are the supplier to a subcontractor on a project. So or you could be a subcontractor. So maybe you are the ductwork subcontractor to the mechanical subcontractor on a project, or maybe you are the electrical supplier to the subcontractor on a project. Maybe you missed your deadline to record a lien. Maybe you missed the deadline to make a claim on the general contractor's bond, but have no fear because maybe the subcontractor has a bond. Now, this bond is not recorded in the public records. So you're not going to be able to find it there. So how do you get your hands on a copy of this subcontractor bond? The party that is most likely willing to give you a copy of this bond is the general contractor. The general contractor has a copy of the bond because they're the ones that demanded the sub provided. So if you send a written notice to the contractor for a copy of the bond, almost certainly they will provide you a copy. You can ask the subcontractor for it, and you should do so, and you should ask for it in writing. But I can't guarantee you that they will give it to you willingly. Now, when you use SunRay for your notices, one of the things that they put in their notice is a statement that says that if this job is bonded, please send us a copy. We have in the past used that statement as the basis for suing people, saying that you had a bond, you didn't give it to us, we requested it in our notice to owner. Look, here's the line in our SunRay notice to owner that says you needed to give us a copy, and you didn't. And by not doing that, we were prejudiced. So know that it's in the SunRay notice to owner, but you can always make a subsequent written request to the contractor for a copy if you want to verify. Now, if you have a claim, if you have a copy of that bond, you can make a claim on it, and they will have to pay you just like the general contractor's bond will have to pay you. The nice thing about a subcontractor bond is that you don't have to comply with all the time requirements because it's not a statutory bond. It's a sub bond, so you just have to follow whatever the process is in that bond form. So you get a copy of it, and then you do whatever it says that you have to do to make a claim. So let's talk about two other potential avenues of recovery. So one is a lawsuit for breach of contract. So what are the elements to sue someone for breach of contract? So first is you have to have an agreement with another person or an entity. It's great if it's in writing, but it's not required. We can have a verbal agreement, and based on that verbal agreement, you may owe me money, and I can sue you based on that verbal agreement and the fact that you didn't pay me. The other writings that can support this claim are a proposal, a quote, an invoice. Some of these may or may not be the contract, but they would evidence the existence of the agreement. So again, the best thing you can do is have a formal written contract, but just know that even if you don't, you still have the right to get paid and sue someone for breach of contract. Now, in your written agreement, if it has a pay when paid provision, you have to be very careful. So if I am the electrician on a project and I haven't been paid, if I sue the contractor who hasn't paid me, but they haven't been paid either, and I have a pay when paid provision in my contract, I may not win my breach of contract action because they didn't breach the contract because they haven't been paid, and I agreed that they don't have to pay me until they've been paid. So be very careful with pay when paid provisions in your written agreements. Now, many times you can't avoid it, and I understand that, but just be aware before you embark on a breach of contract lawsuit. All right, so let's talk about unjust enrichment. Unjust enrichment is a legal theory that says, I conferred a benefit on you, that's the enrichment part, and I haven't been paid for it. That's the unjust part. So if you have been unjustly enriched, you should have to pay me. Typically, we see these claims against people further up the contract chain than those that you have a direct contract with. So if I'm the electrician, I may sue the contractor for breach of contract, and I would sue the owner for unjust enrichment. So my argument against the owner would be, you have all of my electrical materials and supplies and labor, but I haven't been paid for it. So that's why you are unjustly enriched. Just know that if the owner has paid the contractor, but the contractor hasn't paid you, then no claim for unjust enrichment will exist. So they may have been enriched because they got your stuff, but it wasn't unjustly enriched because they did pay the contractor. The fact that the contractor didn't pay you now becomes an issue that you have to deal with between you and the contractor. All right, so let's recap. Number one, know the basic notice and lien and bond claim rules The more you know about those rules and the more you follow them, the less likely you are to have to worry about missing a deadline. 2, exhaust all available exceptions to the lien law. Maybe there's an exception that gives you a right that you didn't even know about. Next, if you are further down the chain, like a subcontractor or a material supplier to a subcontractor, maybe the sub has a bond that you can make a claim against. That's another avenue of recovery. And then always consider alternative legal claims like breach of contract and unjust enrichment. So with that, Ariella, do we have any questions?
We do have 2 questions. Can the NTO be sent based on the initial shop drawings instead of material?
The answer is yes, but it has less to do with shop drawings or what you're sending. The true test is whether or not you have a contract. So that's going to have to be the analysis of whether or not you can send that notice to owner early, which I assume is the premise of the question. I haven't delivered materials yet. I'm just doing shop drawings. The question is, do I have a contract to do this work? And if the answer to that question is yes, maybe, for example, they signed a credit application with you and they've haven't yet placed a formal order, but they asked you to do shop drawings, you know, I would say it's probably better to wait until you have the order placed before you serve your notice to owner early, because an early notice to owner is considered an invalid notice. Now, what you could do is, if it's a big job, for example, maybe you notice it now, and then for, you know, call it belt and suspenders, you may notice it again later once you have the formal order. But I would be cautious if all you're doing is shop drawings, but you don't have a formal order for any materials yet.
I think the question, and maybe the person that asked this question can state if whether or not I'm correct, but a lot of times what happens is you have the shop drawings, and then unfortunately something happens where the material was purchased and then the contract was canceled. So a lot of concern is real, and maybe or maybe not, but this is for the audience listening, whether or not shop drawings are considered notice. You can notice, and she just wrote, I think, yes. So the issue is not about, it happens all the time where people have shop drawings, materials purchased, and they go, okay, we're canceling it. So unfortunately, and it's really, really unfortunate, that's not considered an improvement to the property. So if it's not an improvement, so shop drawings, unfortunately, and it's a terrible thing. It's like, wait a second, why is this not considered an improvement? It's because you actually have to improve the premises of the property. So unfortunately, you will not have lien rights in that circumstance. So
Correct.
and then I think we have another question here.
There are no lien rights purely for shop drawings. So if all you did is shop drawings, you have no lien rights. Now, if you did shop drawings and then you placed an order for specially manufactured goods that could only be used on this project, not anything else, not special order, but specially manufactured goods that can only be used on this project, then you may have lien rights. There are some rules that govern specially manufactured goods. That's a whole nother discussion. If that's an issue, send me an email. I'm happy to go through it in a little more detail and time than we have right now. So what's the next question, Ariella?
Yep, we have, she said, thank you. Yep, that answers her question. Okay, so the last question we're going to take today, and then again, our contact information is here in this presentation below, so feel free to send us an email at any time, and we're happy to answer any and all questions. What if you deliver materials and the owner changes everything? Can you restart the 45-day period from the delivery of the new materials, provided we did not start work yet?
Okay, so if you have received an order and you've delivered materials, your 45 days has started. Now, if the owner says, thank you for all of these materials, I'd like to return them all and order different materials, that's would technically be a continuation of the first order. So your 45 days has already started, because don't forget, if you order 100 items and they keep 5 of them and return 95, well, that's still the original order. So your 45 days has started to run. So it would not reset your 45 days, but we would have to look at more specifically the facts. I guess if they returned absolutely everything and placed a whole new order, maybe we could argue that that's a new 45 days. If by some chance, I'm assuming that the premise of the question is that the 45 days that you missed the original notice to owner window in the original 45 days.
Yeah, and
Because
I want to make it, yeah, and I want to say to everyone on this webinar, you don't want to think 45 days. You want to think I signed an agreement and or I have a verbal agreement. And as soon as you have that agreement in place, you want to send your notices to owners, full stop. Waiting for the last minute. This is almost, think of like a notice to owner as insurance. You can't buy the insurance after the situation goes bad. You want to send that notice to owner as soon as you start working on the project, or as Alex mentioned before, as soon as it's specially fabricated material. And as for your question, it's really by contract. So this isn't a new contract that you're signing. Based on the question that I see before us, this is the same exact contract. If it's a new contract, then yes, the clock can start ticking as soon as you start the new agreement. And that's how you would basically, I can't say extend because there's no such thing as an extension of time, but as soon as you start a new agreement with this person, and you could start the clock and quote unquote start again. I don't know, Alex, if you agree with what my statement was or is.
Yes, and it sounds like that's pretty fact specific. So I would say, send us an email with detailed facts, and I'm happy to, talk to you about it in more detail. Let's talk about an interesting tool that you can get for free. It's a tool that we have. It's called the Lien. It easily calculates your notice to owner and claim of lien deadline. There's an online version of this tool on the SunRay website, but we have a desk version of it. So you can go to calculien.com and fill in the form, and we'll put one in the mail for you for free. You'll get it in a few days. We do these webinars all the time, once a month. So our next webinar is on September 13th, titled I'm owed $8,000 or less. How do I take them to court myself? We've been advising clients for years that for small cases, they should do it themselves. It's a very simple and easy process. You don't have to spend money on legal fees. The old jurisdictional amount was $5,000. Now it's $8,000. It will soon be $15,000. So even more of a reason to learn how to take someone to court yourself. You can sign up at sunraynotice.com/webinars. And then several times a year, we have a full-on live event. The next one is on September 27th in Boca Raton from 8 to 11. We will take a deep dive into the lien law, contract provisions, and collections. We will answer all of your questions, and you can sign up for that live seminar at sunraynotice.com/seminars. So with that, Ariel, I think we've definitely gone over time, but thank you very much, everybody, for participating. And again, if you have questions, send us an email.
Wonderful. Thank you, as always, Alex. I wish everyone a sunny day.